Well, you know, when someone asks, what's the job of a council member, I always refer them back to the oath of office that you take. And it says that you're going to uphold and defend the Constitution of the United States and of the Commonwealth of Virginia. And that's really it. And so I thought it was very appropriate at a time when a very important amendment is before the General Assembly as a council member is to educate or allow constituents to be educated on just what that amendment means. And I couldn't think of anyone better than our former Attorney General and a state senator as well, and a candidate for governor, our own Ken Cuccinelli. Now, anyone who's known Ken along the campaign trail knows what a student he is of the founders and the founder wannabes. And in terms of all the things that they said and how important they knew personal liberty was, and how concerned they were that their future government, even their own, would eventually, infringe upon their God-given liberties, which is their property, as well as their personal freedom. Property was an integral part of that. And so I think it's all that background Ken will do well as he talks about this amendment. How many people watch the Sons of Liberty thing on television? Anybody? Yeah! Well, it is somewhat of a docudrama, but I think it did get across at just how a few people in the very beginning, putting so much at risk, gave us so much. Because so many people are willing to stand by because, when they don't know, they're busy with their lives. So it's important when we have people in the General Assembly and people like Ken Cuccinelli who are willing to go out and speak up so that we all can know what we have at stake. But in the end, this constitutional amendment will only pass with your hard work, with your calls. But with that, would you give me a warm hand for our former Attorney General, Ken Cuccinelli.
Editorial board. Okay, maybe not so much. It's great to be back with you all. I appreciate John's introduction, and I, especially coming from John, who I think is probably one of your all-stars for sure here at Virginia Beach. And then, of course, the Iron Brigade himself, Robert Dean. That's history. But and I also appreciate John's comments about wrapping this into the founders. We're going to start there, and this is a discussion about fundamental rights, and fundamental rights belong in constitutions. And we had an 8-year run there where we were working on property rights. It took 7 years and 10 months, not that I'm sensitive about that, from start to finish. And that was starting before the Kelo decision. My first bill was 6 months before Kelo, and we couldn't get out of committee. Well, then Kelo happened and took off. Took a long time to get to the finish line. But if you think of this in perspective, we're talking about what people normally think of here tonight as Fourth Amendment rights in the federal Constitution. Well, that didn't happen until December 1791. And those liberties became a nationally debated subject 30 years before that, in 1761. And that's where this story begins. It begins with a case in Massachusetts that was, I don't want to say a contrived case, but everybody knew it was coming. And it was an effort by some businessmen in Boston to challenge the unfettered ability of the king's agents to just go wherever they wanted, in your house, in your business, to look at your books, to basically root around in your stuff to find violations of the law with no cause, just suspicion, or they don't like you. And so naturally, people like John Hancock, for instance, were targets of this. So James Otis was the lawyer in this case, and it was, by their terms, a constitutional case. Now, the English refer to a constitution, but they don't mean what we mean when we say constitution. They don't have a document that they can point to and say, this is our constitution. They have, over time, a collection of cases where certain principles have been deemed to rise to the level of being part of the English Constitution. It's kind of hard to define. They don't actually know. If you put two British lawyers in a room, this is not the beginning of a joke, although it sounds like a pretty good one, actually, especially to my Irish side. But they couldn't possibly agree to what constitutes the Constitution. For us, it's pretty easy. Well, here it is, and here are the 28 amendments. Boom, there it is. Now, how it's applied is where we start to grapple with it. They fight over what is it. So this case, and John Adams was in the courtroom for this. It was that important. It was followed closely in the colonies. And it was an argument that this unfettered ability to invade businesses and homes violated the rights of Englishmen. And that would be a phrase they would have used where we might say it violates the Constitution. They lost. But interestingly, John Adams said later that it was at that moment, and apparently James Otis gave a stem winder of a closing argument, worthy of a Johnny Joannou. They aren't all Republicans. And John Adams later said it was at that moment that the child independence was born. He believes that was the beginning of the American Revolution. It was the first time the colonists faced off with the British on the level of fundamental principles. Now, I would say that the point in time at which the American Revolution began without a break was when the colonists learned of the Stamp Act, which providentially was within weeks of Patrick Henry joining the House of Burgesses. And that's all very interesting history itself. But from that point on, we never really stopped. John Adams says this was the first spark. And so here we are now talking about it 2.5 centuries later. And we have 223 years and a month and a half's worth of history of applying the Fourth Amendment since it was ratified. But as we enter this discussion, one thing I would point out to you, you're all familiar with the constitutional debates. Came out of Philadelphia in 1787, and the Federalist Papers and the Anti-Federalist Papers. And they weren't called that then, of course. They were letters to the editor, is what they were. But they were darn well thought out letters to the editor. And there were folks on both sides. This was a national debate, right? And it took place in Virginia and New York, all across the country at the time. It was widely followed by Americans everywhere. And that was about, forget the amendments, including the Bill of Rights, that was about the Constitution itself and the structure of federal government. No such debate took place about the amendments to the Constitution. People normally lump the Bill of Rights in with the Constitution in terms of the founding, and there are reasons to do that. But one of them is not that it was part of the debate. The main opposition to the Constitution, held by the likes of George Mason, James Monroe, Patrick Henry, was that there was not a Bill of Rights. And yes, they identified things that they thought should be in there, but the debate didn't focus on those particulars. It focused on the fact that there wasn't a Bill of Rights. And while we think of the Constitution almost presumptively today, the vote in Virginia, the test vote, for those of you who've been to conventions, was 88 to 80. It was very close. 5 people vote the other way out of 168. That's far more than the entire General Assembly today. If just 5 of them vote the other way, Virginia rejects ratification. The following month, when New York went, the second most important colony at the time, their ratification vote was 31-29. And they intentionally scheduled theirs for after Virginia. And it's very reasonable to expect that if Virginia had said no, New York would have said no. And the fact that they'd already gotten 9 states wouldn't have mattered without Virginia and New York. If you just think of the original 13 and the map thereof, those are 2 big holes. It's hard to have a country like that. So this was an important addition. James Madison didn't think they needed a Bill of Rights, but when he wasn't sure he had the votes for ratification, particularly from the Kentucky counties, and then they were part of our counties, he committed to a Bill of Rights. He promised he would go get it in Congress. Of course, he barely beat George Mason in his congressional election, but he kept his promise with a Federalist Congress that really wasn't very interested in a Bill of Rights. But he got it. And among them, of course, was the Fourth Amendment. And I would just ask you to picture how the discussion went. There was a few people sitting around a table. It was not a national debate with a back and forth of what should this say, how should this read, and what should be the outer limits of government authority. And also remember, at that time, there was no expectation that it would cover the states, only the federal government. It wasn't until the 1920s, and formally at the federal level in '61, until the Fourth Amendment was applied to Virginia. The Bill of Rights was to protect us from the federal government. The 10th Amendment left everything else to us and the states. Us meaning the people and the states. It's too bad more of it didn't stay there. So fast forward a few hundred years with some experience, some of it good, some of it bad with the Fourth Amendment. If on this sheet we passed out, it's exceptionally boring, no graphics, none of Robert's usual pictures and stuff. But I was trying to fit everything in just with 2 pages. So I would apologize for afflicting you with my left-brainedness, but the amended version, the substitute version of what is now being debated is in that first block of italicized language. I don't even put on there the Virginia provision, Article 1, Section 10. And the reason I didn't even write it in there is it's irrelevant. Article 1, Section 10 of the Virginia Bill of Rights simply says general warrants will not be allowed. General warrant is what I mentioned to you about the king. Okay, guys, go wherever you want. Let me know what you find. So that's forbidden under the Virginia Constitution. Rather ludicrously, just from a textual standpoint, at some point, I don't even know when, Virginia's Supreme Court read it to be coextensive with the federal Fourth Amendment, despite the fact that the language is ridiculously different. So it isn't really relevant to our discussion. So the comparison I'm making here is to the Fourth Amendment, because that's really the standard that we're working with, and that we have worked with really for the lifetime of everybody in here. After we give you the whole proposal there in italics, we literally break it down 1 sentence at a time. And what I'd like to do is just talk you through each of those and explain why they're there, and explain some of the challenges. Rich Anderson, who is my delegate up in Prince William, retired Air Force colonel, brought this as HJ 578 on the House side. which was left in P&E's subcommittee this morning with the only peep raised by the aforesaid Johnny Joander. It's still alive on the Senate side in the form of SJ 302, which I should have written on here but forgot. That's Richard Stewart's bill. It will be heard in Senate courts this Wednesday. So please email those Senate courts members before Wednesday. They're going to hear it Wednesday afternoon. SJ 302. This is not a bill, it's a resolution. So it says SJ instead of SB because it's a constitutional amendment. So SJ 302. And Richard Stewart is the senator, who is a former Commonwealth's attorney. He's a former prosecutor, which is a nice credential to have when you're having this discussion. The main opposition to this is coming from law enforcement organizations. And I love law enforcement. I'm a big supporter of law enforcement, almost as big as constitutional rights. So, and just so you understand how the debate's going in Richmond, they look at this and they see new obstacles to conducting investigations. They don't look at all the rest of it. They see that and they come in and say, we shouldn't do this because of these negatives. It is a legislator's job to weigh the positives and the negatives. It's not really their job to do that, although I certainly prefer a more straight-up debate like that. The first sentence you can see there, the word businesses is in there with papers and effects, familiar language from the Fourth Amendment, but businesses is already covered by case law, Fourth Amendment case law. So while you don't read it in the Fourth Amendment, the law of the Fourth Amendment today covers businesses. We just made it explicit. So in the same way they can't come in your house, they also can't come in your business. Same standards apply. More critically, we added lands, L-A-N-D-S. Right now, the Fourth Amendment, if you think of your house and the shrubs outside the house and then out to the picket fence, the Fourth Amendment protects you from the shrub line. That's called the curtilage. A judicially made up word and zone of protection that is awfully hard to find in the Fourth Amendment. So apparently, a man's home is his castle and his shrubs. My wife would be pleased. I don't really care about the shrubs. But that is where the Fourth Amendment today, that's where that protection starts. Lands pushes it out to your property line, out to that picket fence. And you'll notice that there are two other principles, both Fifth Amendment principles, that find their way into Fourth Amendment law. One is property rights, protecting you and your property. And two is that you cannot be compelled to incriminate yourself, which is why papers is in here. Those are tightly related historically, going back to England, not just to the US. There was a major case in England. We had our major case in 1761. They had theirs in 1765. The Entick case, where a member of Parliament was publishing newsletters considered libelous of the king for Fenn. Well, the agents of the king came and grabbed all his drafts and other things to prove libel. Well, he sued and said, you can't come take those. And that was the heart of their case. All of the founders knew about that case. All of them knew about it. They were far better read than we are. They followed those sorts of contemporary, frankly, philosophical, judicial discussions far better than anybody in Washington does, right up to the president. But again, that is a bipartisan problem. I don't think anybody here would dispute that. So lands is a big addition. It's a property rights addition, but it pushes back out to the edge of the property line. Now, when we think about law enforcement challenges, this stops them from doing some things they can do today. And on two conditions, they can come back over that line and do their investigation. One is called exigent circumstances, which we get to. Say a hot pursuit, someone's in danger, etc. Immediate things. The other is when they get a warrant, having shown probable cause to a judge why they should get it. It's a good law enforcement standard. So far, I'm waiting for one of them to come in and say this is going to be an impediment and blah, 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 but so far we haven't had enough discussion for it to happen. And I want one of the committee members to say, let me just understand this, Mr. Law Enforcement person. Are you telling me that you're conducting investigations today without probable cause? Suddenly the light feels very hot. I'm waiting for that. Yes, sir?
I'm just curious about drones and surveillance.
Yeah, that factors in here for sure.
Outside of your property line, but that's still gathering information about your personal data and stuff. Is that included or implied in sentence 1, or is that something that's not addressed?
Well, the Fourth Amendment boundary for that is going to be pushed out to your property line. So it is going to affect the use of drones. It is going to push back the use of drones. Not 100%.
So the airspace above your property is, no?
Well, no. I mean, planes can fly over your house, and they can take pictures. One of the yes, satellite imagery. That's right. One of the abuses in Virginia recently was exactly that. It was they flew a plane over some guy's house, took pictures, put them on the front page of the newspaper. These are government agents. So, you know, they do some pretty abusive things. This will help rein that in. Is it an absolute? No, it's not an absolute. But it does push the line back, which is the goal. Then the other addition you can see here, let me make one more and then I'll come back to you, is the addition of all this digital, electronic data, information, and so forth. And this is intangible property, is what lawyers would call it. But some of the most important property we own today as individuals is in the form of electrons, right? There are whole companies built on nothing more than ideas that are implemented via computer, the internet, whatever it may be, but they're stored digitally. Sometimes not at their place of residence or in their business. So, do you get Fourth Amendment protection in the cloud? Government doesn't think you do. That's particularly touchy for law firms. Can I store my data in the cloud? I don't. Because as long as the government thinks they can take it in 6 months and I'm suing the NSA, well, lo and behold, it wouldn't surprise me a whole lot for them to come grab it. Sir, you had a question?
That was my question, sir, regarding the internet intrusiveness.
Yeah.
Thank you.
Yeah, and a major motivation here is, and this is where the 21st century Fourth Amendment moniker comes from, is adding all that electronic data. Missouri just made this change to their equivalent of the Fourth Amendment, and on the ballot it passed 75-25.
Wow.
Another squeaker. Well, I mean, think of the Property Rights Amendment. It took us forever to get that on the ballot, but when we did, the people of Virginia went for it overwhelmingly. It was on the ballot in 2012, and a majority of the people who voted for Mitt Romney voted for it, and a majority of the people who voted for Barack Obama voted for it. 75-25 was that vote, and I'm convinced that's about what this would be if it made the ballot. Now, we obviously go beyond just the electronic data. We've added lands, for instance, just in that first sentence. The second and third sentences have actually caused the most problem. If I might say, the most confusion. There's a lot of bad case law out there on the Fourth Amendment, and we're trying to fix some of it. I'll give you an example. There's a case not too long ago called Hine. It was an 8-1 U.S. Supreme Court decision in which, in North Carolina, a police officer pulled somebody over who had a busted tail light. Well, the law in North Carolina is 2 busted tail lights. So he was wrong on the law. And so went through the normal steps of a stop and discovered other criminal stuff. Well, Hine tried to get it suppressed. And the Supreme Court ruled, I kid you not, that even though the law enforcement officer got the law completely wrong, that they were going to admit the evidence discovered in that stop. So you don't even have to be right, and the evidence you discover comes in. 8-1. This language in sentences 2 and 3, especially that third one, where the unreasonable search or seizure includes those based on a law that is not valid. So a mistake of law would be thrown out. Yes, ma'am.
Is that a United States district?
U.S. Supreme Court, yes. Yes.
Who was the one who ran it?
Don't hold me to this, but I think it was Alito or Sotomayor. I forget which one. Yeah, Sotomayor is very good in this area. Nobody's reporting this. Yes, sir.
Wasn't there something about if the officer makes a mistake, it's all right because it was an honest mistake?
Yes. Yeah, this didn't address if you were making something up to pull someone over, which, especially in our racial history of Virginia included, was a way that black citizens were harassed by white law enforcement. I mean, there's a bit of that in history. So where you have malicious intent, that isn't addressed by that ruling. But if you think about it, it's a license to be sloppy. I mean, you just take them at their sincerity, which I do. But if there's no consequence, you bring that standard down and down. And who pays for that? Individual citizens pay for that. And you'll see here the immediate or exigent circumstances. This is what I was talking about earlier. If you have an emergency going on, if someone is in danger, they can act. This isn't a restriction on that for police officers. Also, if they observe traffic behavior, swerving in and out of a lane, you don't have to go to a judge to get probable cause to pull them over. And that leads us to sentence 4, where one of the major changes we made from the originally proposed language was that this addresses written warrants and other demands for information. We say other because they can be called subpoenas, they can be called, when I was Attorney General, they were civil investigative demands. There are some AGs across the country making quite an infamous name for themselves in how they're tormenting various institutions and entities that they don't like, for very little reason than that. And right now, I'll just use Virginia as an example, the Attorney General enforces consumer protection laws, fraud laws, a variety of others, but we use those. We use civil investigative demands that we issue. Now, any of the ones we issued while I was AG, I'd have been happy to run through a judge and would have met the standard. But that was not the legal process. And do I trust Mark Herring to do that? No, I don't. And you really, when you think about things like that, you shouldn't think about Mark Herring or Ken Cuccinelli. You should just think about the process and the office. You depersonalize it. What is the ideal structure, knowing that human nature is to abuse power? Well, you don't need to go much farther than that. We have lots of examples. But the written requirement takes you out of the traffic stop, all of those things, any observed criminal behavior by law enforcement. The main impact of all of this, in terms of just the number of times it would come into play, is overwhelmingly on what I would call bureaucratic law enforcers, not public safety law enforcers. Yes, it will affect your police and deputies and so forth, but for every one time it's going to affect them and they're going to have to change how they operate, it's going to be 10, 50, 100 times for the zoning official, for the tax department person, et cetera, et cetera. And I can think of examples of all of those. But that's a way to limit the scope of this, but also define it in a way that isn't as threatening to law enforcement. And I think we all want them to be able to pull people over when we see unsafe behavior, right? So we don't want to get in the way of that. Yes, sir.
What can the people do when an attorney general for a city or a community refuses to prosecute a crime?
Commonwealth's attorney is the prosecutor, and when they won't prosecute, and they generally have exclusive jurisdiction, your only alternative is to vote them out in the next election. That's all you've got.
Yeah. Wow. Fact.
And if crimes against you, you can sue them.
That's true.
4 years ago.
That is true. But that is, you know, that's got serious problems. I mean, so we see the president doing it. They can selectively enforce the law, and they have done that. Yes, I think of the Richmond Commonwealth's attorney where where there was an instance of some folks getting around the abortion consent law, parental consent law, where they took a girl in to get an abortion. This is a facility, I'm embarrassed to identify, but, and the Commonwealth, it's a misdemeanor, so it has a 1-year statute of limitations. So if he doesn't prosecute it in that year, it's gone.
There was, what I was thinking about was Northern Virginia prosecutors refusing to prosecute voter fraud because he said it wasn't worth the money.
Well, I would say that a lot of prosecutors view their role in that area as that is an annoyance. To be candid, as AG, I found them often saying, look, I've got rapes and murders I got to deal with. This is just not worth my time and effort. And, you know, when they all keep doing that, needless to say, it becomes essentially a free, get-out-of-jail-free card for people who want to commit fraud. Wow. And we do not have a fallback. I tried to fix that. In fact, I did fix it to a certain degree, is the Attorney General now has additional authority over election law violations. So it's dual authority, which I think is appropriate. And basically, whoever prosecutes first should handle the case. But that also assumes there's manpower there to do it. The Attorney General's office didn't get any prosecutors funded to do that. So it comes out of the other capacity we've got. I saw a hand. Yes, sir.
You were talking about this is more targeted towards the administrative side as opposed to law enforcement. I've had the unfortunate experience to work with my neighbors in regard to abuses by the Child Protection Services. And all of these things you're addressing were grossly violated by the Child Protective Services repeatedly. And in addition to that, they were actually removed children with no evidence they came on a witch hunt, and it's a common practice. Does this rein that in?
It forces, with the exception of some evidence of immediate harm, it forces it all through a judge. That's your backstop. It doesn't keep people from lying in those hearings. It doesn't keep them from lying to judges. I'm of the view that every Commonwealth's attorney ought to be prosecuting 1 or 2 perjuries a year, just so everybody knows they'll prosecute perjury. But it will affect that aspect of it. I hope that helps.
Yes, thank you.
And you know, Child Protective Services units they differ wildly from locality to locality in the quality of their work. It is unbelievably varying, and there's no state level accountability. And there's very little, I mean, your city council members, John can say yay or nay on this, generally don't even think about the fact that if they all pushed hard enough, they could fire a person X, Y, or Z. It's a really strange system. One of the things I had intended to do if I won the governor's race is actually centralize it, which is not my usual direction, but it's for purposes of accountability. There is no oversight. So, and they aren't the only agency to have very little practical oversight. That's why you need structural hurdles in place.
That's why I was asking.
Sir.
Sir, sentence 4, who and what defines a neutral judge or magistrate?
It's just a judge or magistrate. The point is, when I'm issuing my own subpoenas as Attorney General, I'm not neutral. I am a party to the subpoena. So you can't be on one side and decide. That's all that neutral means. And there are an awful lot of agency-administered demands that don't go through a judge. So they would be in that position to provide the filter. That's what that means. Yes, ma'am.
I've seen several articles recently that addressed permission given by one inhabitant for the entrance of, you know what I'm saying?
Yes.
For the entrance of
Law
police
enforcement.
or law enforcement.
Yep.
But not given by the other inhabitant. And at one point, I think the case was an individual was within the home, who was the owner or the legal resident, and denied law enforcement entrance. But after that person left, another individual within the home allowed them.
And as long as the person granting the permission is appropriately there, they can grant the permission. And can law enforcement keep coming back and asking other people? Yes, they can.
So
that's not addressed by this. That is not addressed by this. All of this comes into play when permission isn't granted. That's really what this is about. This doesn't affect consent. And a lot of times in a case like that, the litigated issue will be, was appropriate consent requested and granted? Because once consent is granted, it's a carte blanche, it's a blank check. You know, among the work I've done as a lawyer over the years, I've done some courts-martial as a defense attorney, and God bless my military clients, they just want to say yes to everything. They're used to obeying authority, they're trained to obey authority, and when authority shows up at their door, they want to say yes, and the answer is no. Polite, respectful, and it isn't that they won't come in, it's that you make them execute the warrant. Because then the only things they get are what's particularly described in the warrant. And once consent is granted, it's literally an open door in every respect. So, sir.
I just want to point out, there's a lot of people over here raising their hands.
Yeah, I'm used to looking right, not left, you know, I'm sorry. Yes.
Ken, you said something earlier about the fox watch and the hen house approach that we have right now in the law. And, you know, I know you've been attorney, it is what it is. Yeah. There's no doubt about that. We're one Commonwealth attorney because his buddies are doing something wrong and go, oh, I'm not prosecuting, and declare prosecutorial discretion. Now, I recently asked Barry Knight and a few others to fix that. So we won't have this approach. We're going with I.E. Bob McDonald, Will Sessoms, and some other people we have going on right now that are outright breaking the law, and they can stop them happening. But I want to know why, because you've been Attorney General, you've been in the House, why is nobody trying to change it? Or are they happy with it because they're benefiting from it?
I'm not sure, I'll make a simple statement, I'm not sure how you completely fix that. If you mandate prosecution, well, there isn't a prosecutor's office in Virginia that would be utterly buried. They have to let some things go to just get through their workload.
But if you violate the trust in the public officials, you've got no public anymore. And that's where we're at with these. That's how bad it is.
Well, that's why I think the better solution is to give more jurisdiction, meaning more layers of jurisdiction. Again, that doesn't sound like the usual conservative approach, but you're not adding any new offices. If a Commonwealth's attorney won't prosecute a case, then the AG should be able to. Doesn't mean they will.
I've asked for that, and I'm going to send it out tonight in a mass email. I've asked for that for the second time, so it gives the discretion to the Attorney General to make it happen, because it stops the good old boy network in place.
Right.
And what it seems like, and even on the federal side, the feds are tired of it too. They don't like what's going on because they know it's dirty, but they don't have discretion either until something's violated. And that's another.
You mean until Mark Warner does it?
Yeah. Thank you very much. Besides the point.
The governor's chief of staff?
Yeah, absolutely.
Yeah.
So
well, you know, if only we had evidence on tape. Oh, wait a minute, we do.
You got my point here, and it's sort of frustrating when you've seen it take place for 14 years like I have, and then I've got letters back from the Attorney General, including you.
Well, look what all of us are seeing in Virginia. You know, Bob McDonald's going through what he's going through, and you know, judge what you will about it, but you know, when you look at what he is alleged to have given for what he got, and then you compare that to Mark Warner's offer of a federal judgeship, and the chief of staff of the governor's offer of any open directorship.
Right.
That's that's a pretty clear something to give.
How about
in
$212 million worth of favors? Right. $212 million worth of favors. That's substantial, what do you think?
Well, and you talk about undermining trust in the justice system. That kind of disparate treatment for rather obvious political reasons
sure.
Is among the most severe.
Yeah, and that's my point. Yeah. And it should be addressed immediately instead of gifts.
Yeah. Well, there's a lot that needs to be addressed there. Yes, sir.
While you're on that subject, I was a little off from what we were talking about with Bob McDonald. Was it not true that the state would not prosecute him and they had to go to federal prosecutors to do it?
No.
They did it under the state?
No, they did it under their federal statutes. The state did not proceed in light.
That's what I thought.
I can't tell you exactly why. I referred gift matters to the local Commonwealth's attorney, who then, as I understand it, waited on the outcome of the federal matter and so never proceeded.
Right.
Because from his perspective, even if he thought something had been done wrong under state law, it would have been piling on to a ridiculous degree. So, but that process was begun and then either not completed, because that was out of my hands, or decided not to proceed. So, sentence 5. Yes.
Hi, this is American TV show. I have a question for you about college, please, in the Fourth Amendment.
Yeah.
Does a college have a right to go inside of a student's trunk? Do they need a search?
Well, first of all, you want to break it down: private or public college?
Private.
Private, they can do whatever they want. They're not an arm of government. That's between them and their student. Now, they can enter into contractual relations to govern that, and usually they do, and most students don't read them. I mean, they just don't. It's different for a public college because they are an arm of government, and so all constitutional and due process requirements cover public schools, including universities. So they have different requirements automatically that private colleges don't have. Doesn't mean they are dealing with it like law enforcement would deal with something. Nonetheless, they do have certain requirements. I was on the Judiciary Committee at UVA when I was an engineer there, and I jokingly referred to it as the lowest court in the state. Because we had all those requirements. The key ones are the notice and opportunity to be heard. So, but we didn't go exercise subpoena power. We didn't go looking for things. We didn't have that authority. So, great.
Before you leave this area, I'd like to really address this issue just based on your constitutional act about it, what your opinion is. The constitutional role of sheriffs in Virginia doesn't seem to be, based on what I can read about it, it seems to be that it's really an unrealized condition where we could really follow through on enforcement of constitutional violations through the sheriff's office. Nobody seems to have pursued that angle.
Let me give you an example that maybe exemplifies what you're thinking about.
Pardon me?
Let me give you an example and you tell me if this is along the lines of what you're thinking about. So, a federal agency overflies some farmer's farm out in the Shenandoah Valley, takes pictures, shows up on his doorstep with the pictures and says, you have to rearrange your operations thus and how to comply with our regulations. Never invited on the property or over the property or anything else. My view is, if a sheriff met those regulators at the property line and said, if you want to come on this property, you come back with a court order. A, he'd be elected for life. And B, that's his accountability. It's to the people. And the sheriff can play. Now, there are localities where sheriff isn't the primary law enforcement officer anymore. In Northern Virginia, we only have one of our localities operates that way. Virginia Beach, you are not that way. You have police. But there's no question, and you see it in other states happening, where sheriffs are the ones who put themselves on the line at the tip of the spear to push back on this stuff. And in my view, that's part of their role. That's why we have independent constitutional sheriffs. Is that kind of what you envision?
Well, literally, I would argue that if Terry McAuliffe has violated the Constitution, if we had a sheriff worth his weight in gold, he could actually swear on a warrant for McAuliffe's arrest and walk into the office, and if he's willing to go to jail or whatever be confronted with it, then he could actually.
Well, so long as it fit within his jurisdiction, he could.
Yes.
So.
We got one that's complete.
We don't have any federal sheriffs, which probably could. That would look like. But, yeah. Sentence 5 has a very distinct purpose. It's this is called the third-party doctrine, and it gets rid of it in Virginia. Person's disclosure of papers or effects or communications doesn't give up their Fourth Amendment rights. And this goes back 40 years. You may not, actually I'll do a quick little survey. And I'll just register as, would you be surprised if? To learn that government agencies can go to your bank, ask for your bank records, be given those bank records with no warrant, subpoena, or anything, and it does not violate your Fourth Amendment rights.
Oh, the IRS.
Okay, so I am registering general surprise at that concept.
Yeah.
That's the law according to the U.S. Supreme Court for the last 42 years.
Wrong.
Yes, it is wrong. 6 years after that case, in a telephone case, the Supreme Court ruled that when you dial a phone number, you give that information to the phone company and thereby abandon your Fourth Amendment rights to the protection of that information, including the number you call, how long you call, anything else they can get once it leaves your phone.
So does that include an email address? Email?
Yes.
Metadata, right?
Yes, that's called metadata. That's actually, I'm suing the NSA over exactly this. That's at the federal level. That's called the third-party doctrine. Once you give anything to a third party, under any conditions, you've given away the opportunity for Fourth Amendment protection. This sentence eliminates that rule.
What about when you mail a letter?
When you mail a letter, the face of the letter you're putting in the public domain, much like you are your license plate when you drive off your driveway. Everybody can see it. There is nothing wrong with them looking at that and cataloging it, and they do that, so you all know. They take pictures and they catalog a lot of this mail. No, they cannot open the mail. Just like they can't listen to the communication. They can't listen to your telephone call, but they can get every bit of data about the telephone call that they want. So if you call a suicide hotline at 2 in the morning and you're on for an hour, do I really need to hear the conversation to know everything I need to know from that phone call? No, I don't. And as General Hayden, jumping over to my NSA lawsuit, as General Hayden, who used to run the NSA and the CIA, said, we kill people based on metadata. Yep. That's how confident they are in it. And when you look at what can be done with compiled massive amounts of data, it's amazing what can be figured out from that information. Wow. So this would get rid of that third-party doctrine. Third-party doctrine. Now, when these cases went through the Supreme Court in the 70s, the bank case, the Miller case, and the phone case, which is Smith v. Maryland, it started being taken up in some states. 7 states have explicitly rejected this third-party doctrine. They have said, our equivalent of the Fourth Amendment does not allow this. The Idaho, and these are widely varying politically type states. California and Idaho are among the 7. My personal favorite is the Idaho Supreme Court, which said, and I'm paraphrasing, we lament the grievous error of the U.S. Supreme Court and will not subject the people of Idaho to such a nefarious ruling. We look forward to the day when they correct their error. That was awesome. That was very good. Unfortunately, that day has not come yet. But I think it may be coming. It may be coming. A year from this June, I think one of the NSA cases will probably be ruled on by the Supreme Court. And I think we're going to get, I think we'll see electronic data pulled in under, at least to some degree, under the Fourth Amendment, which it is not now. It is not now. But this doesn't rely on them. This gets rid of this third-party doctrine in Virginia entirely. Now, interestingly here, for all of the parade of horribles we get for people opposing this amendment, there's not much they can say about this, because 7 other states have done this. There's no unintended consequences. It has not impaired those 7 states' ability to conduct appropriate law enforcement at all. Well, there goes that parade of horribles. How terrible. How horrible. We've lost our parade. At least on this one. Very straightforward, very simple. It really becomes a question of what standard you want for your state. Then the last sentence is what's called the exclusionary rule. Law enforcement already works under this. It already applies to law enforcement. If they violate Fourth Amendment standards and get evidence from you, the exclusionary rule says that that evidence, nor anything garnered by use of that evidence, can be admitted into a court against you. The exclusionary rule. This simply applies it to all of the administrative hearings and agencies and so forth. If they violate these provisions, then whatever they gather would have to be excluded as well. No remedy, no good behavior. Yeah.
Playing devil's advocate, how does, and this is fantastic by the way, but how does this help, or does this kind of shield illegals? I mean, what does this do for the illegal immigration population, with the rise of it coming, you know,
yeah,
coming throughout the United States?
The usual tool used there is zoning. So let's just talk about that one, where you've got overcrowded houses and so forth. If you've got 7 cars parked in the front yard, you've got your probable cause. If they're there every day, you can stand on the public street, see it, and you can count, you know, that's 7 adults, that's more than this house qualifies for zoning. You go to a judge, and yes, you've got to go to a judge, which you don't have to do now, and still conduct the same kind of zoning inspection that you can do now. But you do it with the filter of a neutral judge. And, you know, I am not so zealous about rooting out illegal immigration that I am willing to just cast aside constitutional structures. So it doesn't get in the way, in my view. Yes, there's another step. And that additional step, by the way, for every government agent who has to go through it, is a disciplining feature of the system. It makes them present their best case. And I think we want them to do that. I think we want them to do their homework. We want them to do their homework. That's right. It's like getting rid of the rule from the Hine case. If you make a mistake in your law enforcement, you shouldn't get the benefit of what you gained by making that mistake. Absolutely. Otherwise, there's no incentive to go do it right. Right. Yes, ma'am.
What about something like the Ryan Frederick case in Chesapeake?
I don't know about it.
It was in no-knock, and was they looking for drugs, and they did that, and then they gathered information, violated his rights, and prosecuted him with that data. And he went to jail.
Well, actually, he went to jail for shooting a police officer.
He was jail, yeah, shot a police officer.
Well, because it was a no-knock warrant. He was housed.
Yeah, one of the, and obviously there's a lot of touchy elements to something like that, but when you go in without a warrant, if you're deemed to be a trespasser, there is no shooting of a police officer, it's shooting a trespasser. But that influences judges in how they decide those cases. Just to use my Northern Virginia experience, one of my wife's classmates from high school, Sal Colosi, was killed by a SWAT team while he stood on his porch holding nothing because a door hit one of the SWAT team members who, for those of you who shoot, know he was violating rule number 1. Finger is not on the trigger until you're ready to shoot. Right. And the trigger got pulled and hit him square in the chest, and he's dead. But in Fairfax, I'm convinced, and I am also convinced Fairfax isn't alone in this, when they were asked, why was a SWAT team arresting this guy for running a numbers thing. The guy is an optometrist. And those numbers on the side. Well, it's numbers, it's gambling, it's organized crime, so therefore it's very dangerous. So this was a high-risk warrant. The chubby optometrist on the front porch. And I believe the reason they do it is when the next year they go before the Board of Supervisors and they say, my gosh, we had to deliver 450 high-risk warrants last year.
Numbers.
Make sense to you all who've been watching government a little while? And so there will be a time for a no-knock entry. There's an appropriate time for that as a law enforcement tactic. But it isn't all the time. And when you go in that way, you're taking certain risks, because until you establish your legal ability to be there, you're a trespasser, as far as the people in the house are concerned. Yes, sir.
How can the state turn around and give illegal aliens driver's licenses?
Well, Virginia doesn't.
I understand Virginia doesn't, but other states do. I'm trying to understand how they can do it if they're illegal. How can they give them a license to drive?
Well, because they don't care. I mean, the 10th Amendment lets states do an awful lot of things. And we don't have to like what Maryland does. In fact, I think that list is pretty long. But
does Virginia have to recognize that license?
No. No, but of course, if we won't recognize their licenses, they're not going to recognize ours either.
Would that be considered a nullification?
No. No, nullification is when you go outside the process. Like I got accused of being a nullifier for suing over Obamacare. No. A nullifier would be the ones who say, we're just not going to implement it. You know, the old 4-year-old in the corner. And that's nullification. Interestingly, the biggest nullification example in the country that I know of in recent years is the vote by the people of Colorado and Washington to legalize marijuana, knowing that what they were legalizing was in the face of federal law that illegalizes it. So it's those folks practice knowingly nullification, and it has a role. But you know, as an attorney general, I couldn't ever accept it as a matter of my role.